So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Black Lives Matter apparel has been considered not concerted activity, and we need to talk about this. So, the National Labor Relations Board regional director issued a complaint that charged Whole Foods Market with a violation of the National Labor Relations Act because it had a dress code that prohibited wearing Black Lives Matter messaging during working time, even though it still permitted the wearing of a union affiliated pin, button, or insignia for the purposes or supporting or opposing a labor organization or otherwise legally protected activity, provided that it is no longer than the employee's name badge. So, let's first look at the act that's being cited as where Whole Foods Market violated. It's a really important section of the National Labor Relations Act. Section 7 says employees shall have the right to self-organize, to form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in other concerted activities for the purposes of collective bargaining or other mutual aid or protection, and shall also have the right to refrain from any or all of such activities, except to the extent that such right may be affected by an agreement requiring membership in a labor organization as a condition of employment as authorized in Section 8A. Section 7 has been almost universal and broadly interpreted and has been for quite a bit of time. And the administrative law judge found that the most important question was whether or not the employee conducted the employee conduct constituted an appealed action that would directly impact their working conditions, either by requesting or imploring employer or government action on a grievance or concern. So the administrative law judge is questioning whether or not this specific BLM messaging actually had something to do with the work environment. To give an example of some of the messaging, they have Kayla Green, who began to work at Whole Foods Market in April of 2020. She was a prime shopper in the e-commerce department, working at the Bedford, New Hampshire store. And she reported to an assistant team leader from June 4th to June 30th. Again, this is in 2020. Kayla Green wore a black mask to work at the store, which said Black Lives Matter on the left side and I can't breathe on the right side, using ironed on letters. In addition, she made one for her mother, who worked at the same store, that said I can't breathe. And she said she wore it to show solidarity with the movement because she believed that Whole Foods Market held the same beliefs she did. And this had a lot of testimony, as you can see here. Someone went to work June 26th wearing the BLM mask, called into the office, and then sent home when refused to wear the mask. This went on and resulted in this person getting attendance points for missing work. And ultimately, they left the store. The general counsel brought expert witnesses, a professor of African American Studies at Princeton in New Jersey, as well as Dr. Donald Davison, a professor of political science at Rollins College in Florida, as they were mostly bringing history and context to Black Lives Matter in the context of the workplace. So the general counsel attempted to bring as many speakers and subject matter experts as possible. But ultimately, the administrative law judge said there's simply no evidence that there were any employee concerns, let alone complaints or grievances about racial inequality at Whole Foods Market. And that was really the crux of the issue, is that they weren't actually complaining about something specific that was going on in the workplace. A lot of the clothing that was worn was ultimately worn as kind of a protest against the store cracking down on the messaging. Because the store continued to tell them no, they could not wear it, it started to spread in that way, and that is what the general counsel for the National Labor Relations Board attempted to argue. Ultimately, the administrative law judge did find that the dress code that was in effect from 2013 until 2020 was unlawful because it prohibited employees from displaying any visible slogan, message, logo, or advertising, and requested that they make the change to that. Now, they found that this specific situation with respect to BLM was not a concerted activity, but that the dress code rules were presumptively unlawful. Now, this is where things get difficult. Now, that was in San Francisco. In Seattle, in Region 19, an administrative law judge found the opposite, that grocery stores unlawfully discriminated against workers wearing Black Lives Matter pins and masks. And it was, it was National Labor Relations Board again, but a different opinion. So this will ultimately go before the National Labor Relations Board as a whole. No more admin law judges, I'm sure. But you can see that even the administrative law judges for the National Labor Relations Board are a little bit conflicted on this matter. What do you think about this? Does it violate your reading of the act? Let me know in the comments down below. Like, share, and subscribe, and we'll see you on the next video. Bye, guys.